Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, Chairman of the Board. The board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malice, and Peter Owen. Mr. Melnick will not be joining us tonight. Also present is the professional staff, including Stephen Rissy, a coordinator for the Board of Zoning Appeals, Arlova Vaughn, zoning administrator, Simon Keynes, administrative technician, Cliff Hogan, assistant to the zoning administrator, and Christine Sanders, assistant county attorney. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not seen the report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance. And we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint size and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not of so general or recurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance. That granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property. That the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the front table on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for appellants in appeals, 5 minutes for applicants for use permits and variances. We've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient for use permits and variances. After the board's gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Madam Zoning Administrator.
Thank you. Yesterday morning, as I believe most of the applicants and all of the board members know, zoning staff learned that mailed notifications associated with the entire September BZA agenda were not sent. And while this is not a legal requirement for every case that the BZA hears, it has been the practice of this board to send notification to adjacent property owners for years. After reviewing the requirements found in the Code of Virginia and the Arlington County Zoning Ordinance, staff believes that the legal notice requirement has been met for all of the use permit requests. Because written notification is required for BZA appeals, staff believes this case cannot be heard tonight and can re-advertise to ensure compliance with the notice requirements in advance of the October 2017 hearing. There are a couple of other cases for which applicants were already requesting deferrals, which could also be voted on tonight. In the PowerPoint presentation that we've created, staff has provided some additional information that illustrates adjacent neighbor comment, either in support or opposition, which we have already received in writing for each case. So while zoning staff and the county attorney's office believe that the legal notice requirement for the use permits on tonight's agenda have been met, we do have information regarding potential carryover meeting dates in October should the board choose to defer.
Comments, questions?
I'm sorry that we're in this position, that you're in this position. I know that it wasn't directly zoning's error, but we did not follow our procedures, our normal procedures for notification, and I don't know how we could justify hearing cases tonight.
Mr. Owen?
I agree with Ms. Malice's view on the matter. I also I appreciate the county attorney and the zoning administrator's view on the notice requirement, but I could find in my quick study no case law to support that view, and I think that the structure of the statute, and to my mind, makes me not fully confident that even if we were to grant use permits tonight, that they would stand up if they were challenged by people who did not get actual notice. So I think also as a potential protection for those who are seeking use permits, as well as for one of our purposes as a Board of Zoning Appeals is to protect the rights and interests of neighbors who may not have any idea what's going on. I also do not think it is fulfilling our mission to decide any cases tonight.
Does that extend to deferral requests and withdrawals?
No, I think the statute says no special exception may be granted except after notice and hearing as provided by 15.2-2204. So I think anything that's not a grant is an action we can take, including a deferral, including even a hearing. I mean, we could, if people are here, if someone says, I'm not going to be here next month, I'm going to be out of the country, can I speak now as to the item? It's an advertised hearing. We're assembled. We're not violating the open meeting law. So to the extent the board wished to hear from anyone, and I think that would be on the record and it would be information we could consider when we make a decision. But I think to to grant any use permits, I think is not consistent with both our purpose as well as our, what I would say is our statutory mandate.
So, Mr. Smith.
I take a slightly different position. I think that we've got a number of applications here and staff reports that indicate staff support for the granting of variances, for the granting of use permits in a number of cases which are fairly routine, and I think a number of those cases have demonstrated in their applications the outreach that, to me, satisfies notice, and even given that the legal notice, as the county attorney's office has advised, has been met in that case. And while our practice normally has not, it's my position that in those cases that are non-controversial, where the county is advocating the granting and the neighbors have, and the applicant has done sufficient outreach to enable the neighbors to make a informed decision as to whether they want to support or oppose the use permit, I think it's perfectly appropriate for us to take those cases on tonight. To the extent that we have 3 votes for the granting of a use permit, I'd be happy to do those. Part of that is for what we lawyers call judicial economy. Sometimes when there are T's that have to be crossed and I's that have to be dotted, when it is more economical to ask the parties, are you offended by us proceeding even though an I has not been, the jot has not been tittled and the T has not been crossed? Are you comfortable with us proceeding? You waive any objection. Now, Mr. Owens makes the point that an interested party, a neighbor, who might want to object had not been notified through our customary practice, not our legal practice, not our legal requirement, but our customary practice. My point is that if a applicant has made sufficient outreach to those neighbors and they have demonstrated support in their application, we should proceed on those if the party, the applicant, is comfortable, and certainly the county, which is advocated in many of those cases on the granting of the use permit. I just don't think it's efficient to put the whole agenda off until some other time. That's my position, Madam Chair.
That's a position with which I agree. So let us discuss, Mr. Owen and Ms. Malice. Do we go through the agenda, or are we at an impasse, given that we don't have an odd number of people here?
I appreciate my colleague, Mr. Smith's argument, but I believe that we cannot ascertain to the extent that we think we can that notice has been taken. I'm thinking of cases where a written notice coming to a household enables all parties in the household to have been informed. I'm also thinking of cases where the property is occupied by a tenant and not the owner. And so I find it difficult to be able to ascertain that notice has been received based on neighbor input. And I think, Mr. Smith raises the economy issue. For us to go through each of these cases and try to figure out where we think it has been met and where we think it's lacking, I think just adds another number of minutes to each case and without possible conclusion. We don't know how long it would take for us to figure out if all the right people have been notified. So I'm falling back on the fact that we have adopted procedures that the public relies on, and I know people who would be very disturbed if they were in the situation of not having received a notice. I don't know if this applies to any of the neighbors here, but I know people that would be very disappointed if we did not follow what our procedures, which we have in fact been discussing, are quite minimal for notification at this point.
Madam Chair,
Mr. Owen.
I would also say that in my year and a half on the board, I've seen examples where there was a signature from a neighbor, and then after the mailing went out, the spouse found out, or some other, person of interest found out about the appeal, and then the consent was withdrawn, or the approval of the neighbor was withdrawn. So I think there's good reason to believe that with such a, this many cases, the chances that one or two of them would fall into that category seems not insignificant.
And so, Madam Zoning Administrator, in this situation where it appears that we aren't going to come to a consensus, what is the recommendation for if we were to defer this entire agenda?
So
Clearly not my preference, but
yeah, it's hard to recommend something that I don't advise. So I'm not sure how many cases we have already scheduled for October, at least a dozen. So there's 14 already on the October agenda. There were 21 or 22 tonight. I would not advise scheduling all of those for the same evening. The regular hearing date is October 18th. We have 3 other potential dates in October if you wanted to split it in half.
well, if would we choose if this entire agenda was deferred, it would be deferred to a date certain apart from whatever the October agenda is, to which items may be added. Now, there is a complication in that some of these items on this agenda are deferred to October, which could be after the fact, in which case they'd have to go to November.
You lost me on that one.
A couple of items on this agenda, tonight's agenda, are recommended for deferral
Correct.
automatically to October. Unless the recess date is before that, you're going to be hearing something after the October meeting that's recommended for deferral to the October meeting.
Got it.
Which means that those items are automatically going to be kicked to November.
So there's one potential date that's before the 18th,
Okay, and what is that?
the 16th. So it's the same week. It's a Monday.
Okay, everybody.
So, Madam Chair,
That's a Columbus Day, right? Are we open for business?
Before.
It's what?
That's the week before. Columbus Day is the week before.
Oh, right, got it.
So we would like to defer, if we defer the agenda, we would defer it to a date certain. Does it matter? Can it be our regular hearing date that we defer this to and put the other items into
It's your decision.
so that everybody leaving here today would know what date they were coming back on?
The October meeting is not advertised yet,
Not yet.
so the applicants may have been told what the date is, but it's not out there.
The dates are published on the website, so all the dates for the year are already known for every month.
On the face of it, I would rather defer this agenda, if we have to do it at all, to its own date. I don't think we need to make it any more complicated than it already is.
Madam Chair,
Mr. Owen.
I will support you if you want to continue to make it uncomplicated, but I will observe that all of the people sitting here have been quite inconvenienced if we do something like this. And so I think that there are at least 2 accommodations that I can think of that we might consider offering them if the rest of the board would be so inclined. One is to, some of these applicants might themselves, because of their own vacation schedule or whatever, might prefer to ask us to assign it to one date or the other date in October, or even to go to November at their request. And so we might have the opportunity to give people a little bit of convenience, and to mitigate their inconvenience in that respect, and then shuffle around the regular hearing items that are already scheduled for October to balance it out. So that's one thing. The other thing is whether or not we do that, and again, if you were strongly opposed to that, I'm not going to push it, but just a thought. But the other thing is that I do want to reiterate that I don't think that I would have any objection to hearing out people who are maybe there's a family and the husband and the wife can't both come the next time and someone wants to just put something into the record. I think that this hearing is fine for adding things to the record. Our meetings are recorded. We take minutes. Everyone is going to be on notice of everything that's said tonight. So I think that if it would be convenient for people to say, hey, I came prepared to talk for 3 minutes tonight, and I'd like to come to the next meeting and just say, hey, remember what I said 3 weeks ago? Remember that. If that would be more convenient for them, I would be open to that as well. But I just offer those as suggestions to help move things along and maybe make things a little bit shorter at whatever carryover meeting we do have.
Madam Attorney, is that
You could
acceptable?
certainly hear cases tonight and defer a decision until another date certain.
Is that what you're talking about?
Madam Chair or Attorney, if we hear an item tonight, are we closing the hearing?
Not if you don't vote to close it.
Okay. So additional people could come and talk.
Correct? You could leave the hearing open. You could continue it to another date certain.
So in the event that someone here wishes to speak tonight because they don't plan to be at the next meeting, they would not be here, they would not possibly be there to hear testimony from others.
True.
And that could, and then therefore not have an opportunity to rebut or answer questions. So there is, I think that's something for people wishing to testify to consider, is that if they don't come to the hearing, others may speak about their project and they won't be there to hear what's being said.
What are the 3 dates?
Monday, October 16th, Monday, October 25th, 23rd, sorry, and Wednesday, October 25th.
Okay, so one of them is before the BZA. So what you're suggesting is that we go through the agenda tonight and let whomever wants to speak, speak?
I'm not suggesting that.
I don't think that's a good idea for a number of reasons, but I think that we should, if we're going to defer, we defer the whole thing to a date certain. I'm certain, I think it should be before the next meeting. I would advocate for the 16th myself.
Is everybody present, available on the 16th? Minta?
Yes.
Just a second. Okay, so the general consensus appears to be to defer the agenda to October 16th. Is that correct?
That would be fine with me.
The dissenter?
I think that that's a reasonable course of action. I think that's a reasonable course of action. I do think now we have a question of whether or not we want to hear from the public before making a decision on that.
Okay, Ms. Malice, what do you think about that?
So the question is, should we let the public input into this decision on whether to defer it? I don't know how many people want to speak to this, but I don't, unless you have a different suggestion on how to proceed. I mean, I guess I'd be interested in that, but I don't know what the protocol is. This is kind of an unusual situation
To say the least, this has not happened before.
in terms of.
Man, I think these items are on our agenda tonight. We advertised an agenda. They're on the agenda. We're holding a public meeting that we advertised. We actually have some other business still to conduct, the minutes and possibly an appointment. So, so we're going to conduct some business tonight. We're assembled. It's on the record. So I think that it's customary when we are considering a deferral that we are open to hearing from anyone, any party of interest who's present. That's our custom as well.
But that usually is in a case where a duly advertised item has been heard in its entirety, and I don't believe that's this situation.
Right, that means we'd have to call the item and hear the whole item before we acted on it.
That's right.
And in this case, if we did that, we would do everything short of acting on it.
Right, and we would, but on the other hand, and we would do it all again next month.
Yeah, I don't think that we want to have two complete hearings. One without a decision and one with a decision. Okay, let's have a motion.
Madam Chair, I'm sorry, but if I lose this, we'll have a short meeting anyway. So, but I would say that perhaps we should consider offering interested persons to speak to us on this question for some very limited period of time, to take speakers for 30 seconds for whoever wanted to speak for a minute. And maybe I don't think everyone here would want to address us, but there might be one or two people who would want to make some kind of special pleading or offer a new idea or something. And as long as people are here, it just seems to me like, why not hear what these people who are all interested in these cases have to say about our plans?
It does not look like there's a groundswell. Sorry. This is really obnoxious and unforeseen, as you know. And we only found out about it yesterday, and I know that the staff has reached out to the applicants, but of course couldn't necessarily know who might be trying to speak for or against any particular agenda item. But the general consensus of the BZA is that our customary procedure, while not required by law, has not been followed, and that it appears that rather than having two complete hearings, one with a decision and one without, on the same exact agenda, that the sentiment is to defer this agenda in its entirety to October 16th. And we profusely apologize for your inconvenience and ours.
Madam Chair, I second that motion.
Was there a motion?
Oh, the point you were raising.
I typically don't make motions. Let's have somebody else do it, please.
Madam Chair.
Mr. Smith.
The speech that you just gave describing the condition we're in as a motion to defer to the agenda, the published agenda for tonight's meeting to October 16, 2017.
Is there a second? All those in favor?
Aye.
The meeting is...
Madam Chair?
Mr. Owen.
I would suggest that we could perhaps at least take advantage of the time to approve the minutes and do any appointments that we need to do.
Absolutely.
Okay.
We just approved the motion. We haven't adjourned.
Okay, good.
Sorry. Okay, so given that, minutes to approve from August 9th.
Madam Chair.
The corrections?
Mr. Owen had emailed a question, and I didn't see an answer to that with respect to the minutes. Has that been answered to your satisfaction, Mr. Owen?
No, so my question was that with respect to item V-11296-17-UP1, which was the fence at the corner, remember the fence at the corner? And that one, I think there was a second motion that was voted on that was defeated on a 3-2 vote, and that's not recorded in the minutes. So I think...
It was deferred to October, correct? Or no?
It was.
Yes.
It was. But I think there was a motion to approve it.
You mean an interim motion?
No, that's right. I agree, because I think I made the motion.
I was pushing for approval, and I think it failed 3-2.
So I would suggest that maybe we could just look for that edit, and maybe at the October 16th meeting, we could approve it with that change. So I would move that we
Not approve the minutes.
refer the minutes to the October 16th meeting, but we'll know that our hearing is finished, and we can just approve
We're
it.
hitting considerable home runs.
We have a vacant, we have a new
Coordinator.
coordinator.
Is that
I
what,
would move to,
wait, is that your act?
Oh, I'm sorry, Madam
No, no, I'm just, is that the actual title?
Yes,
No, what
These-
we
but-
appoint,
we appoint a secretary,
exactly.
and I would move that we remove as secretary Mr. Emba.
Pretty harsh.
And thank you for your service, albeit brief. And appoint Mr. Reese
As secretary.
Second.
I'm not going to repeat the part about Sam. All those in favor of appointing Stephen Rissy as secretary to the BZA?
Aye.
Aye. Thank you. Congratulations, or sympathies.
So trial by fire, Mr. Risi. Do we have any other business?
There was, I mean, I don't know, there was a withdrawal. I
Oh,
don't know
yeah,
that
we
that
could
needs
accept
to
the
be
withdrawal.
carried over to October. It's just acknowledgement of that.
I missed that.
That was the bed and breakfast request was withdrawn.
Supplemental to your packet.
Right.
But given, Madam Chair, my position on that would be, given that we've deferred the agenda, that's an
Fine.
agenda that.
Okay,
that's an
it's
agenda
over.
item. You know, it's
Okay,
it's really a.
it is.
Stay on the books a month longer.
The board made it a moot point anyway, so.
And they're going to apply to, in writing to withdraw. I presume from what I read that the written request has not been received yet.
We have now.
Oh, okay, so
Yeah.
they're eligible to receive a partial refund.
Yeah.
Okay, but I mean, given that that's been met, it doesn't really matter that we push
Got
it
it.
to the 16th.
Okay. I feel like we've completely lost control.
So the variances, everything is,
Everything's pushed back.
The agenda in its entirety is what we deferred to October 16th. Okay? Any other business? You want a motion to adjourn?
I move to adjourn.
Second.
All those in favor?
Aye.
Thank you.